Lauren Lewis from Trudie Broekmann Attorneys.
And I'm Trudie Broekmann. We're a law firm specializing in consumer law based in Cape Town, South Africa. We are often at our firm approached by vehicle owners who are having real trouble with their cars. As we specialize in consumer law and we apply the Consumer Protection Act, we've recently spent a bit of time just thinking how we can streamline our use of the Act in order to best protect our clients. It's generally a bit of a David and Goliath fight where our client plays the role of David. So we need to be very clever about cost-effective, swift strategies where we use the law, but also use a few cheeky alternative arrows, which are in our quiver, in order to best look after our clients' interests. So the type of claims that we deal with include a vintage car which was missing certain metal parts of its gearbox, an Audi Q7 with issues with its turbo, an Audi S6 which ran perfectly but was advertised as having satellite navigation and it turned out to not have that. A Merc sports car with leaking windows, Porsche Boxster which had a design defect which affected its visual appeal but not its functionality. A truck purchased by a construction company which suffered huge losses when they discovered that the truck was unreliable and they couldn't transport their teams or their building materials with it. Then we've had 3 Ford Rangers that keep on breaking down, 4 or 5 Ford Cougars that have either self-ignited or the owners run the risk of them self-igniting, and consequently they are not reliable vehicles. A vehicle purchased to transport a disabled son of our client, which turned out to not be able to take his wheelchair. In other words, it was unfit for its purpose. Now, the CPA, the Consumer Protection Act, applies not to every single sale of a motor vehicle, but only to specific aspects. And we just want to warn you right up front in case you don't fall within the right category. It applies wherever the supplier is acting in the ordinary course of their business. So if you've bought from a dealership or from a person who regularly buys and sells vehicles, then you'll be fully covered. If you've bought in a private sale, the CPA won't be of assistance to you. Nevertheless, you're welcome to contact us, but we may have fewer arrows in our quiver for that matter. Then the CPA also applies whether the vehicle is bought or rented. And if you are a person who's bought in your own name, you'll be fully covered. But if the car is bought in the name of your CC or your employer's company or something like that, in the name of a juristic person, then only some of the benefits of the Consumer Protection Act will apply to your situation.
The Consumer Protection Act provides various remedies for a consumer who has purchased a defective vehicle. In terms of Section 55 of the Consumer Protection Act, a consumer has a right to receive good quality goods. This means that your vehicle must be usable and durable for a reasonable period of time, must be free of defects, and must be in good working order. Then Section 56(2), or Section 56 rather, of the Consumer Protection Act incorporates the right for a consumer to receive good quality goods into the agreement that is concluded between the consumer and the supplier. And they do this by referring to the implied warranty of quality. So Section 56 provides the consumer with a remedy in the event that a consumer does purchase a defective vehicle. In terms of Section 56(2), if you purchase a vehicle and within a period of 6 months after taking delivery of that vehicle, it breaks down for whatever reason, then you as a consumer are entitled to demand from the supplier a repair of the vehicle, a replacement of the vehicle, or a refund of the purchase price. Then if you've elected to have the vehicle repaired and the repair work is done, and then within a period of 3 months after that repair work has been done, the same defect or a different defect manifests, then you as a consumer can go back to the supplier and insist that the vehicle be replaced or that the whole agreement be cancelled and you receive a refund of the purchase price. It's also important to be aware that in terms of Section 56(3), you do not have to do this within 6 months of taking delivery of the vehicle. It could be that you had the vehicle repaired, and in the 7 month after taking delivery, it breaks down. As long as the repair work or the second defect occurs within 3 months after the repair work has been done, then you're entitled to protection under Section 56(3). There is a further section in terms of the CPA, and that is Section 61, which conveniently applies to not only natural persons, so an individual who's purchased a vehicle, it also applies to juristic persons, which would be a company, a closed corporation, a trust, etc. In terms of Section 61, a consumer is entitled to claim damages from a supplier where a defective vehicle has been supplied and the consumer has suffered damage. The sort of damage that we've claimed for our clients under Section 61 has been where the vehicle's been repaired for a few months and our client has been forced to make use of some sort of taxi service like Uber, or has been forced to incur rental car expenditure. We have claimed that expenditure back from the supplier. This could also apply to a company where the vehicle was purchased for the company, for example, a construction company where it's a truck used to transport workers or construction materials, and where that truck is out of action for a period of a few months while it's being repaired, the company can claim from the supplier any loss of profit or any other expenditure they may have incurred as a result of that defective vehicle.
Even if your vehicle is working 100%, but it's different from what was advertised, so let's say it doesn't have a feature that was advertised on the advert on Gumtree or whatever, then you can also come to us and we will be able to cancel the sale and get you your money back. Then we really need to consider as lawyers whom we're going to be claiming from on your behalf. So we would normally claim from the dealership, but we don't stop there. We try to work with the entire supply chain, which just improves your chances of having success as a consumer. So we look at the manufacturer, we look at the, if it's relevant, the importer, we look at the dealership. Then if there's a financier involved, so I'm speaking about a finance house like MFC, West Bank, any bank that's financed you by way of vehicle finance, then we include them as well. Why do we do that? Well, for two reasons. The first one is that their contract always says that they've bought the vehicle on your behalf from the dealership, and then they're on selling the car to you. So they really are the supplier, the retailer from whom you've bought. If you've had the car repaired, then we'd include the repairing garage if that's relevant to your situation as well. We've had quite a lot of success of including the financier in the past. We've had clients who have just driven the car back to a West Bank office, handed the keys plus our letter of cancellation to the manager there, and received their purchase price, or at least the portion that they paid, the deposit plus the first few installments until the car broke down, received that back quite successfully. So that really increases your chances of getting a quick resolution to your claim. What do we claim? Well, depending on your particular situation and the timing, you're entitled to claim a refund of whatever you've paid for the vehicle already, a repair, in other words, your repair costs for the vehicle, or a replacement vehicle. And we really recommend that our clients consider replacement vehicles seriously. Even if you have lost faith in the type of vehicle, take the replacement vehicle as an option, consider it, and just resell it. Take the money and run and buy yourself whatever your heart desires at that stage.
If you have purchased a car that is giving you problems and is defective, and you'd like to make use of the protection available in the Consumer Protection Act, you might want to know how that practically works. What we do with our clients is we will have either a telephonic consultation with you, perhaps a face-to-face consultation, or even an email exchange where you'll explain the defects in your vehicle, what steps you've taken with regards to the chats you've had with the dealership or the financier. We will then draft a very detailed letter of demand setting out all the defects of the car and claiming in terms of either Section 56(2) or 3 of the Consumer Protection Act, wherein you would like a refund, a replacement, or repair of the vehicle. Or we could claim in terms of Section 61 of the Consumer Protection Act, where you've suffered damage as a result. So we claim that damage, those damages from the supplier, who's the dealership, financier, etc. Once the letter of demand has been sent, there is quite a period that you'd need to wait. So I would suggest about a month or two where we attempt to negotiate with the supplier. That's quite a few phone calls trying to convince the supplier to either replace the vehicle or refund the purchase price. If we are unsuccessful in that negotiation and the supplier is not willing to refund your money or replace the car, we will then suggest a number of options. We could either report the matter to the media, so we could use either the conventional press or social media, and we've had quite a bit of success using either social media or the conventional press. If you have a finance agreement in place, we can report the matter to the National Credit Regulator and then pursue the matter further at the National Consumer Tribunal. Where there's a finance agreement and you've chosen not to report the matter to the National Credit Regulator, there's an option of stopping the debit order payments under the agreement. This will result in possibly a summons being issued against you by the finance house, but this is not necessarily a bad thing. What we would then do is simply defend that summons and institute a counterclaim based on the defects of the vehicle. So claiming in response to the summons a refund of the purchase price or replacement of the vehicle.
So there are two challenges really that face us when we're dealing with car claims for clients. The one is the timing, the second is the cost, and the two go together. The longer the matter takes, the more it costs you in legal fees. So we have developed two strategies with regard to dealing with these two challenges, which I'm going to sketch very briefly. The first one with regard to timing is, first key is that you need to be patient, if we can ask that gently. It takes a while to assimilate all of the facts that we need to receive from you, get all the documentation together, make the calculations, check that the law is perfect in our letter of demand, and then send the thing off. And then after that, there's a period which is often a little bit lengthier than a client would like, where we wait for a response, negotiate with the suppliers in the supply chain to whom we've sent the letter on your behalf, and give them a very good chance to come to the party and sort you out in terms of your claim. That's the first aspect. The second aspect in terms of the timing is that we can often reduce the time spent on a matter by making use of the first strategy, and that is that we involve either the media, the normal media, or social media. We found that really focuses the attention of a supplier on the matter, and we often get a very good settlement offer, and we can settle the matter right there. So we ask you, if you do instruct us, that you decide whether you're interested and willing to make use of social media or of the ordinary media. We're not scared, and we have in the past regularly issued press releases on behalf of our clients. We have a whole database of consumer journalists, and we have good relationships with all of them, so we're very confident on that front. The second strategy is a sort of a proactive passivity, and that means that where we don't succeed with the press, or where the press is unsuitable to use in your situation, we recommend that you just stop paying, okay? And that's the passive part. The reason that is proactive is that will motivate and focus the attention of the supplier to get going from their side and to issue a summons against you. So that sounds like a bit of counterintuitive advice, doesn't it? Rather sit back and wait to be sued yourself. However, from a procedural perspective, which we can explain the details to you if you're interested, it really helps if the other side is the one that's issuing the summons. It also makes it much cheaper for you, so that really affects your legal costs. And once the summons has been issued by the financier or the supplier of the car, we are easily able to put in a counterclaim that will sort you out in terms of your remedies under the Consumer Protection Act. Thank you. If you have a claim like this, you are most welcome to contact us. Give us your details, tell us your story, and we can give you some suitable advice. Details on the screen.